Okay. Good afternoon, everyone. Welcome to the University of Richmond Law School. Today, the Intellectual Property Institute is here to continue our Evil Twins debate series. This is the third, I say annual, although we skipped a year. I guess I could still say it's annual. Count it as annual. Third annual Evil Twin debate. Our evil twins today, and there's been much debate as to who is the evil twin, right, is Professor Jay Thomas from Georgetown University Law Center and Professor John Duffy from George Washington University Law School. And today we're debating the topic, Bilski and Patentable subject matter, method or madness. To begin, I'll provide a short introduction of the issues. For those who are scorekeeping, Professor Thomas will have 12 minutes to argue his side. Professor Duffy will have 15 in his side, and then a 3-minute rebuttal for Professor Thomas. And then we'll have questions. We'll open up to questions from the audience, and then we'll go have some refreshments outside. This is the third Evil Twin debate hosted here at the University of Richmond, and we've been covering really important intellectual property topics related to various fields. This series and its name comes from the notion that experts often disagree on fairly crucial, hot topics in intellectual property law, but at a personal level they are very friendly to each other. Hopefully that'll maintain today. We therefore seek to bring pairs together of scholars who can air their disagreements in a very friendly exchange, serious in substance but lighthearted in tone. In keeping with that theme, and I've said to me this is my favorite part of it, not to couch the subject, the lighthearted tone is that I present the two debaters and I've had each of them write the other's bio. Jay wrote the bio for John, John wrote the bio for Jay. In order of their appearance, here is what John's bio of Jay is. Georgetown professor John J. Thomas is widely known as a leading patent scholar and an extremely dapper dresser, which you can... and this is not just for today. His current intellectual projects include, 1, protecting the public against the advent of socially useful business innovations that would not be created or disclosed without the inducement of a patent. And 2, reviving widespread use of gentlemen's pocket handkerchiefs. There we go, okay. As part of the former project, he wrote a highly regarded article entitled The Patenting of Liberal Professions, which so rhetorically persuasive that it led the Patent and Trademark Office to make many of the same gaffes and guffaws in developing its position for the Supreme Court case Bilski versus Kapos. In contrast to his success on this front, Professor Thomas's quest to revive the popularity of men's pocket squares remains a lonely endeavor. And looking out, it looks like it is still lonely. He had hoped that at least he could reintroduce a modicum of panache into the wardrobe of male law professors, but alas, even that more modest goal has remained maddeningly elusive. Professor Thomas also works as a consultant to the Congressional Research Service, providing advice on patent reform issues. It is widely known among the I actually even had to say this pronounced inside the Beltway, that members of Congress and their staff have kept patent reform legislation pending for nearly a decade just so they could continue to receive Professor Thomas's witty and learned papers. Both of Professor Thomas's current intellectual products are adamantly opposed by Professor Duffy, who wants nothing more for the culture to embrace business method patents and to renounce pocket squares. Here is what John Duffy's bio is, written by Jay Thomas. As a former law clerk to Justice Scalia, the member of the Republican presidential candidate John McCain's Justice Advisory Committee, Professor John Duffy plays the role of conservative law professor. But his right-wing bona fides have been undone by a flattering lead article in Business Week magazine that labeled him a scholar activist. So much for that coveted Court of Appeals appointment of the next administration. Indeed, Professor Duffy takes particular delight in wreaking havoc upon the patent system. He was the intellectual light behind the recent Supreme Court opinion in KSR versus Teleflex, which effectively invalidated tens of thousands of issued patents, single-handedly. He inflicted further chaos upon the intellectual property laws by suggesting that a decade's worth of Patent Office Board opinions were improperly decided, an argument that sent congressional staff scrambling. Now Professor Duffy is at it again, asserting before the en banc Court of Appeals for the Federal Circuit and anyone who will listen to him that methods of doing business and actually doing just about anything else ought to be patented. At great risk to his already dwindling conservative street cred, Professor Duffy believes that the invasive government regulation via the patent system would be in the best interest of virtually every marketplace participant in the country. While we can't speak to his sonorly splendor, Professor Duffy is likely the fastest patent professor ever, having recorded a ridiculously fast full marathon time of 2 hours and 24 minutes. Wow. But in the opinion of Professor Thomas, at least, he can't run from the weight of argument opposing his support of patents on all areas of endeavor. This now is going to seem lame, the intro to the topic. The questions of eligible patentable subject matter are fairly widely debated and incredibly timely. We've got the Supreme Court looking at Bilski versus Kapos, the argument set for this fall. Some would argue that patentable subject matter requires things that are industrial or technological products or processes. This would be Professor Thomas's school of thought. Others argue that the requirement is much broader, allowing much more to be patent eligible. That's Professor Duffy's view. To give an example, and I just take the claim from the case in Bilski itself, is a method of hedging financial risk eligible for patent protection, assuming this method meets all of the common requirements for patentability, which begs the question, Bilski and patentable subject matter, method or madness? I give it to Professor Thomas.
Well, thank you very much for having me today, Chris, and I'm grateful to the University of Richmond Law School and to everyone who's come here today to hear me out. And let me also thank my debating partner for driving down here with me today. You can see, actually, I'm sort of in the dark side, and John's over on the light side. But you'll discover, in truth, in fact, our positions are opposite, and perhaps we can make John see the light today, inspired by his seat on this important issue of intellectual property law. Now, when you have one of these debates, a common parlor trick for law professors like me is to let the gallery of issued patents speak for themselves. So I have a handout here that shows some of the recent work product of the USPTO. And what they show is that the patent system has growing ambitions. It has developed to areas of endeavor beyond those of science and technology. So just within this little stack, I have a psychological testing technique. I have a method of interior design. I have a tax strategy savings patent, a method of setting up certain fiscal structures as to reduce your tax liability. I have a dinner party conversation generator, which inspires conversation and encourages social interaction. One of my favorite patents is the very last one. If you turn to the last page, you can see this unusual print right here. If you turn over a leaf, you can see what the origin is, and I'll read the claim. A method of painting using the posterior of an infant. Said method comprising the acts of providing a background media, dipping the posterior of the infant in a paint supply, and stamping it on a canvas. All sorts of patents have issued. Methods of training janitors to dust and vacuum, selling expert advice, encouraging people to have larger orders at fast food restaurants. There's even a patent on getting a patent. The fact is, these patents they're great icebreakers. They're terrific for me in my patent class because I can engage the students, and they're pretty funny at some level. But at another level, they're really quite serious because they create a lot of unique problems for our society that patents on more traditional technologies do not. And we should think carefully before the patent system goes outside its traditional boundaries of technological industrial inventions. Now, I think we need to be careful about a patent bar, a patent office, and a federal circuit that have great interests in expanding the mission creep of the patent system. Obviously, it's in the interest of all those parties to expand the regulatory grasp of the discipline in which they engage. But the question is whether it's really good as a social welfare matter. Now, let me raise just a handful of very significant issues with these patents. Perhaps the least of them is that patents like these and the whole notion of extra technological patents exposes the patent system to humiliation and contempt. The reality is other systems have not followed our lead on this point. We remain an outlier in granting patents in such diverse areas of endeavor. This essentially makes our system and the USPTO a laughing stock. It reduces the respect the public holds for patents in other areas of endeavor, and tends to create other problems for the Patent Office. The fact is, right now, the patent system is a very fragile institution. Some would say it's a deeply troubled institution. This is a time of great doctrinal upheaval for the patent system. It's gone under increased scrutiny, in part because of patents like these. So we have the Supreme Court, the Federal Trade Commission, the Department of Justice, the Department of Commerce, all sorts of agencies gazing upon the patent system. And let's face it, friends, the prognosis has not been good, and the views they've expressed have not always been favorable. Patents like these distract the Patent Office from applications in more traditional areas. Also, they strain the resources of the USPTO in terms of its ability to process the application. It's the duty of a patent examiner to ensure that each patent that is granted is novel, non-obvious, and meets all the other requirements of the patent statute. That's something very difficult for scientists and engineers, for chemists, biologists, physicists, to do in such diverse areas like tax strategies or sports techniques. Just consider the tax law. Many of us here, well, everyone here is a taxpayer. We all have a duty to oblige with to comply with the tax laws. But it can take half a lifetime to master even one subdiscipline of tax law. This hasn't prevented the USPTO from issuing dozens of, almost 100, tax strategy patents, in which the Patent Office possesses very little expertise. Also, just look around. I won't ask for a show of hands. How many of us think the patent system is working well? How many of us think the patent system is functioning at a high level of efficiency? How many of us have seen the growing backlog at the USPTO? Right now, I think the number of applications that are going to be subject to term adjustment, that will have a term of longer than 20 years because of Patent Office delays, is approaching 80%. That by itself is a very significant inroad upon the public domain. By exposing numerous new industries to the patent system who will deluge the office with additional applications, is that something our patent system really can bear right now? I'd also observe, do we want to thrust the patent system upon numerous new industries? We don't give these new industries a grace period with the patent system. We don't explain the patent system to them. In fact, we don't even ask them whether they think patents are a good idea. We just have a court that interprets its old cases and old statutes to say, you know what, these patents probably are acceptable. And that's it. There's no consultation or notice with a significant regulatory inroad upon all sorts of innovative fields. What's worse, there's been no persuasive demonstration that patents are needed to promote innovation within all the new disciplines to which the patent system has been exposed. There's simply no account, no persuasive account I've ever read that shows that finance, insurance, marketing, sports technique, legal argument can all would all benefit from some sort of innovation promotion system. Indeed, we should ask, is innovation promotion appropriate in areas like tax strategy or tax avoidance strategies? Is it a good idea that the Internal Revenue Service is busy cracking down on tax shelters while the USPTO is in the business of issuing patents that promote innovation in this area? As lawyers, we ought to be especially concerned about individuals who appropriate legal argument and tax saving strategies. Again, everyone in this room, indeed all Americans, are required to comply with the tax laws on a voluntary basis. And Congress sets up tax laws so that they influence taxpayer behavior and also so that they raise revenue. Is it appropriate to allow one individual to serve as a roadblock to that? The tax laws have their own sets of fines and punishments. Are taxpayers supposed to comply with patent proprietors as well? It's very disturbing to think that only one person has access to our systems of law, and only one person can make a legal argument that would be patented. But worse yet, patents on commercial strategies, legal argument, all the sorts of things that we've discussed, impose dangerous restraints upon speech and thought. Patents on sales and marketing techniques prevent us from using certain words. We simply can't speak to others as we wish without being obliged to compensate the patent holder. Diagnostic techniques can prevent medical practitioners from thinking. They can prevent sort of looking and making diagnosis of patients' conditions. There are even patents that prevent us from using our bodies as we wish. patents on sports techniques, patents on methods of holding your body to avoid repetitive stress syndrome. It's interesting to compare the patent system with the copyright law, which for all its flaws has a fairly robust fair use privilege and also doesn't prevent independent innovation. It prevents you from copying, but you're allowed to invent on your own. Of course, the patent system has no user privilege whatsoever, and liability for the patent system is absolute. You don't have to know about the patent to be liable for infringement. You don't even have to know about the patent system to be liable for infringement. You may have no idea there's a patent system. And imagine the burden that each patent potentially imposes upon, for example, the tax field. Is it really appropriate to require each tax lawyer, in addition to having to go through Treasury regulations, revenue rulings, the complex body of tax law, to actually have to do a patent search to see if there's in fact any proprietary claim technique that they can't use? Now, I see my 2-minute sign is up. I've got plenty more points, and perhaps I'll have a chance to bring them out later. But I think we should be very cautious about imposing a regulatory regime upon the entire economic endeavor of this country without any evidence that the patent system will actually promote innovation in any of these disciplines. Of course, we see that caution is coupled with the natural incentive that I've mentioned before. As members of the patent bar, as a patent office, as a federal circuit, that possess strong incentives to have the greatest array of regulatory capability that they can possess. All of these to me suggest that a limitless scope of patenting on such things as methods of doing business and other techniques that are not traditionally industrial or technological are unwise. Again, one person's incentive is another's limitation, and we should be careful about those limitations that we potentially restrict upon ourselves and this economy. Thank you.
Okay. My presentation needs to pop up here somehow.
There we go.
Okay, so I've got a couple slides. I also wanted to thank everyone, thank the University of Richmond for inviting me here today to their beautiful campus on a nice fall day, and thank Jay for actually doing all the driving down. It was sort of, instead of a lamb being led to slaughter, he actually drove down to be slaughtered. So I think I'm okay. Jay talked a lot about silly patents. Patents that are ridiculous. And I want to say, in all technological fields, those patents exist. There are patents in the 19th century of an electric hat tipper. There's patents on how to harness the flatulence of cows. These are actual patents. Those things are not going to be excluded by any patentable subject matter test. They're just silly, they're stupid, and the more important part is they don't cause any economic harm. They get issued and no one ever enforces them. So there's no real economic downside. And in terms of bogging down the patent office, the people who apply for those patents actually pay some substantial fees to the patent office to examine their patent. And if it is ridiculous, the patent office can let it out fairly quickly, and we do not see economic consequences flowing from any of those patents. I'd be interested if any of those patents Jay passed out was ever sued upon. I suspect the answer was no, with the possible exception of the tax patent. And that leads us to the more important point, which is really the core of the debate, which is serious patents on real business methods that people are going to practice, that aren't silly, and that presumably meet all the other requirements of the Patent Act. That's an important qualification. All the other requirements of the Patent Act. The most important of those is the non-obviousness doctrine, which is, as Jay's introduction for me said, I was involved recently in trying to actually increase the non-obviousness standard, make it a harder hurdle for people to get over. The Supreme Court has said that the non-obviousness requirement is supposed to identify those inventions that would not have been disclosed or created but for the inducement of a patent. That's a pretty high standard. So what we're talking about are the business methods that otherwise are either not going to exist at all, so they're not going to be a restriction on somebody else's freedom because they just wouldn't exist, or they would remain trade secret. And that has its own consequences. It causes consequences in the financial markets. It tends to increase the lack of transparency which I've heard there have been some problems with recently. And it can actually, I think, have sort of cascading negative consequences. But I want to take the first point, which is why have business method patents become an issue at this time of our history? Because it's true that business methods, historically, there are a few examples in the 19th century, a fair number of examples, but nonetheless, the real controversy and the real flood of business method patents, or rise in business method patents, have happened only in the last quarter century or so. I want to understand why that's true. One common hypothesis is that, look, it's just judicial activism or sort of an activist patent system that has tried to expand its boundaries. And this is a sort of common claim. It's usually targeted against the State Street case, which was one that the first clear appellate opinion that said, look, some of the lower courts have talked about this business method exception, but we want to say with clarity that it does not exist. The business method patents are not excluded from the patent system. And the reason for the hypothesis, I think, is it ties up with our biases or our thoughts about what a specialized institution like the Federal Circuit would do. And Jay actually alluded to this, said, oh, it's a specialized court, it wants to expand its jurisdiction. And so therefore we have this pre-existing legal theory that specialized institutions tend to like to expand their own power. And it was something that people worried about when the Federal Circuit was created. So the bias to think this theory is right, that in fact the reason for the rise of business method patents is because the Federal Circuit, simply being a judicially activist court and wanting to expand its own power, it sort of fits pre-existing theories and pre-existing notions. Also, the district court in State Street actually said, look, there's, this is long accepted exception that you just can't patent business methods. And then the Federal Circuit reverses it. So it looks like the Federal Circuit was doing something that was a sort of quantum change in patent law. And this theory, I've got a couple examples where people make this charge. This is an example from a white paper done by a lobbying organization, the Computer and Communications Industry Association, and it talks about the court being very activist and targets the State Street court and said, look, this decision summarily eliminated the judicial rule. Now, note that, the judicial rule. Okay, we're going to charge this court with judicial activism for eliminating a judicial rule, not a congressional rule, not a statutory rule, but something that the courts themselves put on the statute. Summarily, there's sort of an activist thing that the court was doing. That's the charge. Peter Minnell also makes this charge. It's it's a pro-patent bias of the Federal Circuit, and one of the things he targets is the State Street decision, which laid to the rest the traditional rule barring patents on business methods. So that's the theory, that there's really something terrible that has happened in the last few years, and it's usually targeted at the Federal Circuit. Well, I want to examine that. First of all, when State Street happened, one thing to note about this case, State Street was decided in 1998, and it established that there's no business method exception. One important point to recognize about that is that there was an issued patent in that case. It was issued half a decade earlier. So in terms of charging the court with doing something that's a radical break with the past, we have already an initial problem that comes from the very structure of the case. This is a patent that the Patent Office thought was patentable. And that's also true in terms of, what did the executive branch think about this? Well, they used to have in their statement of the Manual of Patenting Examining Procedures, they used to have a statement that methods of doing business was one of the judicially recognized exceptions to patentable subject matter. That was in 1995. But what happens? Well, in 1996, 2 years before the judiciary recognized the abolition or tried to recognize the lack of foundation of the business method exception, the executive branch eliminated it first. So that's another point. State Street itself was just applying another earlier case in terms of a test that was developed to try and determine patentable subject matter. That might not be such a strong point because you might think, well, the charge of judicial activism just has to step back a few years. The Supreme Court justices have even, I think, sort of targeted State Street Bank. This is what Justice Breyer said in a case on patentable subject matter. His was a dissenting opinion, and he said, well, the Federal Circuit's State Street Bank does say that a process is patentable if it produces a useful, concrete, and tangible result, generally a sort of thought to be a very broad and inclusive test of patentable subject matter. But Justice Breyer says, well, this court has never made such a statement. And if taken literally, the statement would cover instances where this court has held to the contrary. Well, Justice Breyer is right. That court, the Supreme Court, has never said that. Let me show you some of the things they have said about the patentable subject matter statute. Congress intended statutory subject matter to include anything under the sun that is made by man. In choosing such expansive terms, modified by the comprehensive any, Congress plainly contemplated that the patent laws will be given wide scope. Courts should not read into the patent laws limitations and conditions which the legislature has not expressed. And the language of the statute is extremely broad. So Justice Breyer is right that the Federal Circuit the Supreme Court had not said this one test, but they said all these things. And a lower court, and indeed we as lawyers, might think that an appropriate interpretation of the statute is not to read in limitations that are not actually in the statutory text. And certainly the business method exception is nowhere to be found in the statutory text. Indeed, the statute expressly states that any method, without limitation, is patentable subject matter, as long as it complies with all the other onerous requirements of the patent system, all the other rigorous requirements. Another point about this is the federal government actually presented in the 1970s an argument to the Supreme Court that said business methods should be unpatentable. And the Supreme Court declined to rule on that. They had a clear opportunity to more than a quarter century ago, and they declined to embrace that reasoning. The other thing about the government's position is it's very hard to understand how game patents are actually patentable. And that's true under Jay's theory, too. Well, game patents are about amusement, and there are lots of historical game patents. They have been issued continuously for more than 100 years. So it's a little odd for our system to say, you know, the game of monopoly is patentable, but sort of a new way to actually limit monopoly power, a way that is useful and that is not obvious, meaning it won't actually be created or disclosed without the inducement of the patent. We don't want that. We do not want that kind of technology in our society. But we'll have the game. We won't have the real business technology that might be socially useful. The history gives conflicting threads. There are things like lottery patents that exist. There's patents on some insurance systems from the 19th century. In terms of tangibility, which is what the government is arguing now to the Supreme Court, that there actually has to be some sort of tangible product that's manufactured, meaning in our sort of more narrow term of sort of constructed with bolts and nails and other things like that. There have been systems of coding systems issued for hundreds of years. Morse code was patented. Patents on a way of encrypting and decrypting things have been patented. Those are serious technologies, but they actually they fail the government's test that they are proposing to the Supreme Court that says you have to actually show me some physical object which is manipulated or changed in some way. Also, there's, even if you look back at the history, I previously said that the government had previously recognized a business method exception. Well, let's look a little bit more carefully about some of these statements. This is the government's statement that it had in its manual of patenting examining procedure for some period of time. And it begins by saying, though seemingly within the category of a process or method, in other words, though it seems to fall within the statutory language, a method of doing business can be rejected. First of all, not must be rejected, but can be rejected as not being within the statutory classes. That's a pretty mild and weak statement. Earlier versions of this actually said that it could be rejected as abstract, which is a recognized limitation on the Patent Act. You can't patent something that's abstract because you simply can't define it with the particularity that the patent statute requires. And they cite two lower court opinions. That's it. That's the best we have in terms of limiting what is otherwise clear statutory language. So that's sort of a case that sort of says that this development of business method patents is not something that we should have thought is, we shouldn't charge the Federal Circuit, we shouldn't charge activist courts with it, but I still have not put forward an alternative hypothesis. My alternative hypothesis is that I want to say the law has followed the technology. In some ways, I want to embrace Jay's thesis that we should not patent technology. I mean, I think, in fact, we've done that. I mean, but I'm not here to debate that, actually. I'm here to debate that business has become technological. And you don't need to believe me, or you don't need to believe any litigants or any lawyers. Look at what real engineers do. This is Princeton University. This is the Department of Engineering in Princeton University. When they decided to create and organize themselves a Department of Engineering, they thought, you know, we should have a division about financial engineering, and we should put it in our engineering school. Not our liberal arts school, not our English department, not our music department, because what these people do is a lot like engineering. It's not only like a lot like engineering, it's exactly like engineering. It's formulas and math and getting things right and being precise. It's true science. And Princeton is not an aberration. I have a list of all top 20 engineering schools, and they either have departments like this, laboratories in financial engineering, or courses in financial engineering. You might say, well, when did this happen? Well, it began in the 20th century. This is from 1959, sort of one of the first recognitions that this was happening. There was this change that business was becoming more like engineering. And actually, another example, empirical example, instead of just assertions, this is a search of all a database called JSTOR. It's all the literature, all the academic literature. And I looked for instances of articles that use the term financial engineering. And what you find is basically that zero throughout the 20th century until you get to about the last quarter of the 20th century, and especially around the mid-1980s. And then it goes up like a straight line. And there are various graphs that show this. And that means that the engineers, the finance people themselves began to think of what they were doing as true engineering. And here's a blow-up of the various graphs, just doing different trend lines on them. And you might say, well, what should our social reaction be? And I think this is a much broader question than patentable subject matter. What should our reaction be to financial engineering? Because this is a bigger question, and it definitely extends beyond the patent system. And there's one theory, which is let's be Luddites. Let's go back to the good old days when things were about handshakes and looking people in the eye and other things like that. Beware of geeks bearing formulas. Let's have a retrenchment here. That's Warren Buffett. And I'm not so sure he means that we shouldn't have financial engineering. I think he just means beware, be careful. This is new, and don't just get sold on the formulas. But the other reaction is that the recent financial crisis actually was fostered by a lack of transparency. And note that if we don't have patents, there's an alternative to patents, which is trade secrecy. And people are still going to go out there and do models, very complex mathematical and engineering models. If they don't have patent protection, they'll use the traditional alternative, which is trade secrecy, which is going to perhaps have some negative social consequences. How do I think about the financial crisis? Well, you know, the financial crisis that we experienced, that happens in engineering too. This is the Tacoma Narrows Bridge. It's 4 months old. You might look at that and say, where's the bridge? And the answer is, it goes from the water straight up to that hole. In other words, this is a picture of it collapsing. It was a disaster. Fortunately, no one was killed, barely, luckily. That sort of thing does happen in engineering. And what's our normal response? Oh, we shouldn't build bridges anymore? Or we shouldn't allow patents on bridges? Now, our normal response is actually the response that Wall Street is having. They got duped. They got bad engineering. And in fact, this is a MIT, Massachusetts Institute of Technology, a professor of financial engineering who might work in their financial engineering laboratory. And he says, look, the problem here, ultimately, that we've experienced in the last year is not that we've had too little engineering and too little physicists coming into the field. It's actually that we've had too little. And that we need better technology so that we can predict these things, contain them, and not have financial catastrophes. The patent system has historically worked to try to encourage technology. And this is a new cutting edge and emerging field of technology. It is socially beneficial, and the patent system has a role in encouraging it. That's all. Thanks.
Well, John, I enjoyed your discussion very much indeed. And I thought you brought a great historical and lawyerly perspective to the argument. But one thing you declined to do is to take up my invitation to show any evidence that granting patents and methods of doing business or other fields of endeavor would actually promote innovation. Now, the only thing I really caught on that is when you said that under the non-obviousness requirement, one of its aspirations is to ensure that patents get granted only for inventions that would not otherwise have been consummated, absent the patent system. However, of course, that's just an aspiration. Non-obviousness is a pretty thin and imperfect proxy for that goal. Surely we believe that all sorts of innovation would occur, and indeed that's been our history in this country with respect to business methods. Of course, there's been great innovation across many fields of endeavor. Internationally, we seem to be leaders, but only recently have we thought about the patent system. John doesn't like my array of patents from diverse endeavors because he says they're silly and unenforceable, although he does note that one of them actually was sued and was the subject of a large settlement. You know, I guess with the RIA suing housewives and children for downloading songs illegally, my belief that intellectual property owners will somehow restrain themselves from enforcing their proprietary rights has taken a significant blow, and I'm just not as comfortable with you by saying that all these individuals will spend a lot of time and money getting patents, but simply won't enforce them. That's not an account I'm ready to live with for the rest of my professional career. Indeed, business method patents raise particular concerns because of their breadth. A generation ago, someone who invented an automated teller machine, a bank machine, would get a patent on the particular circuits, buttons, screen, and security mechanisms that made up the device. But today's business method patents claim broadly a method of having 24 access to cash through an automated machine outside the facility. Well, obviously, the scope of competitive harms from that broader claim is much more significant than with specific devices that can be engineered around. John likes to point out various uses of the term engineering and believes that this rhetorical flourish somehow has some significant legal consequence. Somehow says, well, it's true that engineering as we traditionally understand it deals with the manipulation of physical and natural laws. And since now we're using terms like financial engineering in order to promote our departments in glossy brochures for the U.S. News and World Report ranking, this somehow is of some seismic legal consequence, and our entire system of competition ought to adapt. Now, I'm familiar with his brief, and I did a Google search this morning with uses of the word engineering. I found religious engineering, emotional engineering, romantic engineering, and yes, even the term sexual engineering have in fact been used. And I'm not sure how far your scope of patenting ought to go, but the fact is clever phrasings and new terms are trendy. I don't think they justify by themselves some sort of enormous shift in fundamental principles of intellectual property policy. John, the last lunge you made, which I was somewhat surprised, you've tied in the grant of proprietary rights into the flaws of our regulatory system for regulating our financial markets. So the notion is, well, we did a poor job as regulators. What we ought to do is hand out proprietary rights. And the desire to sue each other in court for intellectual property violations will somehow substitute or make up for gaps in the regulatory regime under the Bush administration. And I have to say I'm rather shocked about that. Even an early patent law student knows that intellectual property rights is not about regulation, it's about exclusion. And there is no regulatory purpose for the patent law, and we really ought not to conflate or confuse those goals. Well, look, I appreciate the opportunity to debate with John, and again, I thank you very much for having me.
Some time. If anybody has any questions, I've got a mic. I'll stick it in front of your face, and you can ask your questions. Anybody have any questions? Yep, here we go.
Ooh, that's loud. I'm squarely on Professor Duffy's good and light side of the table, so I know who's evil here. But I have a question, Professor Thomas. If you construed these patents narrowly to deal with the breadth problem that you mentioned, and if the 103 obviousness was not merely aspirational but actual, are you still morally against these patents?
Okay, so you're saying if we significantly alter a number of our background principles,
Well, wait. I didn't say that. If we actually enforce the principles we have.
Well, let me say the principle that we only grant patents to technologies that otherwise wouldn't be invented absent the patent system is just one account of the patent system. That's not something with which many people agree. And certainly the Patent Office doesn't do an inquiry to see whether the technology would have been invented in its natural course. So you're talking about an extremely significant inroad upon the patent system. And you're also saying that we'd have to adjust our claim interpretation principles entirely, enablement doctrine, et cetera. To be honest, I would have a great deal of concern about adjusting those principles merely so that we could bring in business methods into our camp in an acceptable way. Because it seems to me wholesale adoption of those principles would wreak havoc upon the technology industries that have traditionally relied upon other principles. So the bottom line is I don't think it's worth it. I don't think those changes would be worth the disruption they would cause to other industries that have traditionally relied upon the patent system and have made investments based upon the patent system.
If I can have a brief response to that. Jay said that this quote that I had about, the obviousness doctrine is supposed to only reward with a patent those inventions that would not be created or disclosed without the inducement of a patent. He's right that that's only one account, but it's the Supreme Court's account of what the obviousness doctrine does. So I think that, and frankly, I think that if we don't have a serious obviousness standard, we're going to have problems throughout our patent system. Jay was actually talking earlier in his presentation about how many problems the current patent system has and how certain industries have come to rely on them, and there's a lot of patent litigation. And let me tell you, a lot of patent litigation has nothing to do with business method patents. The high-tech industry is besieged with patent suits. And if we don't have a good conception of the obviousness doctrine, we're going to have problems. If we don't have a good conception about what the appropriate scope of claims are, so that people only get their contribution and not more, we're going to have a terrible patent system. And I would rather see, Jay talked a lot about the administrative problems. I would rather see administrative resources and judicial resources and intellectual resources going to try to fix those real problems in our patent system so that the patent system works for all technologies, rather than try to exclude willy-nilly various technologies on the grounds of something that's not anywhere in the statute. And indeed, to show how far Jay's point goes, he mentioned in his principal presentation diagnostic patents. Well, now we're not talking about business or some other extreme extension of a new technology. We're talking about medicine. And we're talking about techniques that involve machinery and involve a lot of science, traditional applied science. And his attempt to sort of limit the patent system begins to sweep up those as well. I would rather see our energy devoted towards these traditional text-based, statutory-based principles of the patent system that we must get right. We can't just let the obviousness and enablement doctrines be in a sort of devolved state so that they can't work for everybody.
So you both have provided very spirited and I know heartfelt defenses of your positions. Neither of you, though, to my knowledge, is currently a member of Congress. And so I was wondering if I might ask you each to direct your attention a bit more to the statute and comment specifically on Section 273 and its effect on the question of patent scope.
Sure. Section 273 creates a first inventor defense, which then applies to, the statute says business methods, or I guess methods of doing business is how it's spelled out. But there's no more. The legislative history is actually quite ambiguous as to whether Congress actually thought these things ought to be patented, and it's in terms of their abstract nature. So I have no problem with diagnostic methods that are machine-based. I'm talking about things that are just, you look and you discern a disease just from, without any kind of apparatus, et cetera. It's merely a thought process. The legislative history to 273 suggests machine-implemented business methods is what Congress had in mind. But the bottom line is Congress can't legislate around the Constitution. And we've saw in certain developments in copyright, the Supreme Court pinned a creativity standard upon the language of the Progress Clause. It's my belief that useful arts refers to the manual, industrial, and technical arts of the 19th century, and that's a source of meaning that informs the Patent Act, and Congress can't legislate around that. So that's my fallback position. It's interesting with more recent legislation, Congress has wised up because there are various attempts to limit tax strategies through legislation. And in fact, Congress has now said, we're not actually have an opinion whether these things are valid or not. We're just saying if they are, you have this. So in my opinion, this it does not fundamentally alter the legal position and certainly does not alter the policy discussion of whether business methods are appropriately patented.
Thanks for your question. I think, first of all, I wanted to note in Jay's response, he actually said, well, this might be unconstitutional. And he actually said, he thinks Congress meant to limit it to the technologies, and I wrote it down, of the 19th century. And I think that is a problem, right? That as technology changes, technology not only produces new things in existing fields, it also produces new fields, whole new fields, like biotechnology, where there was a 5-4 decision of the Supreme Court that said, yes, biotechnology is patentable. It was a very close and heated decision with 4 justices willing to say, no, that's just not patentable. Not because it's obvious or too broad, but just we don't like that stuff. We think it's not exactly what the patent system was about. And that was in the beginning of the biotechnology industry, and now there's an enormous industry, and of course it would be unthinkable not to have patents in the biotechnology industry. But that was within 1 vote of disappearing in the early 1980s. 273, I think, is if you apply traditional principles of statutory interpretation to this case, the case that's before the Supreme Court, I think the petitioners win going away. You have very clear language here that's, as Justice Thomas said in 2000, speaking for the whole of the court, extremely broad language, in which Congress has repeatedly actually expanded the statutory scope from broad language to even broader language. And then in 1999, Congress actually added a specific defense for business method patents. And I think that if that were the only thing you had, maybe it wouldn't be such a powerful argument. But on the basis of this very broad statute that already has sweeping, extremely broad language that the court has said over and over again, the court should not be reading in some sort of non-textual limitation. In that context, the addition of a specific provision for business method patents tends to reinforce the sweep of the words. That Congress knew, Congress could read this language, it's extremely broad, and they wanted to have a special rule. Using standard statutory construction arguments, you should assume that that provision should not be rendered not inoperative. And I think that ultimately, we can debate this a little bit, but ultimately Jay's position would be a step in that direction.
Okay, if I could just weigh in very quickly. Of course, at the time of the framers and in its succeeding decades, there was a vast quantity of business innovation. Because as the Industrial Revolution swept through the country, of course, that implied certain ways to organize enterprises and to organize production. Obviously, insurance, advertising, marketing, we're going through vast changes at the time of the Constitution. But none of this stuff was ever patented. As well, of course, it is a standard canon of statutory construction that Congress is presumed to be aware of developments in the judiciary. And we have business method limitations in the case law that presumably was read into Section 101. So I think there are countervailing arguments.
This question also relates to obviousness. Key in determining obviousness is finding out who the faceta is. Considering the vast differences in the purposes and tolerance of risk that different investors have, how will the faceta be determined, and do you think he'll look more like Warren Buffett or Gordon Gekko?
Well, I think that the person having ordinary skill in the art is actually being defined, because if you actually do an empirical study, which I have on my hard drive here, of business method patents, you'll see this ramping up of citations to journals like the Journal of Finance. In fact, one scholar, Josh Lerner from Harvard Business School, did a study in the right around the turn of the century, which said that there was a relatively small number of these citations, but in fact, actually, my study, which is more recent, shows that those citations to sophisticated journals like the Journal of Finance are ramping up dramatically. So we do have a sense, because there is this external art that is there and that is developing. And unlike, religious engineering or something like that, we have whole schools, literally schools, that are devoted to this, whole departments that educational institutions have devoted millions of dollars to. They've hired professors, which is a multi-million-dollar investment for a major institution. They've created laboratories, as the one that exists in Massachusetts Institute of Technology on financial engineering. So there is an art in the traditional sense, an art of technology that is out there, it's developing. And I think that whatever you think about this debate in terms of the legal issue associated with the patent system, one of my big messages, which I hope you take home, is that this is really a major change that is happening in the last 20 years. Whether we patent it or not is another question, but it is a very serious change. And sometimes as lawyers, we don't look over in these other departments of the university or other fields and actually observe what's happening in the real world. So I think there is an art out there. It's developing. Josh Lerner, in fact, who's a Harvard Business School professor, just got his first patent last fall. And, he cites to a lot of people, and you can evaluate, gee, is this non-obvious or not? It's very sophisticated stuff. It's not, how to paint a canvas with a baby's posterior. It's not anything like that. And if you're going to take a course in what he was teaching, and you went in there thinking, well, I know music and art and English literature, I'll do well in this course, you'd be wrong.
I'm one of the veterans of the battle over software patenting that began back in the early 80s, or actually before that. And my impression is that in that area we ended up with mainly focusing on how claims are written, and we're still trying to develop a clear criterion, but that still seems to be where the focus is. I'm wondering if each of you could hazard a prediction on where we'll end up in the area of business methods. Will we develop some sort of a criterion that applies to how claims are written, or will we go to one extreme or the other, either saying all business methods are patentable or none are?
I'll take a shot. Surely a concern over Section 101 law is that the principles can be defeated by the clever drafter. And as someone with a computer engineering background myself, and who wrote claims in this area, obviously the notion was to include illusory hardware or nominal hardware in the claim to sort of instantiate the technique. And if you put it in a bag, it shakes and you can feel it, that sort of thing. To me, the only way around that problem ultimately is to go back to what we were doing in Parker v. Fluke, which is to analyze statutory subject matter at the point of novelty. I think that's the only way you're actually going to get around nominal hardware recitations. In fact, the printed matter doctrine, to the extent it's still around, actually still has that point of novelty approach. I'm not sure that's what the Supreme Court's going to do. What I think is going to happen with the Supreme Court, in fact, I'm fairly confident, is that they're probably going to go even further than the Federal Circuit in restricting the scope of patentable subject matter. So I don't think we'll have to worry about business method drafting, because you won't be able to get any patents on it.
One thing that's interesting, and I have an article coming out in actually the William & Mary Law Review, I see. I just got it to the editor, and finally they're no longer chasing me like a bad debtor. But what that shows is that historically the patent system has toyed with these sort of per se limitations on patentability. And sometimes they've survived for a short period of time, but they all tend to collapse. There have been a lot of rules that have been tried to sort of restrict the scope of human creativity, which is ultimately what we're talking about here. And not surprisingly, human creativity tends to outstrip and surprise people and tends to not get around these rules, but ultimately prove that these rules don't make sense. So, for example, the European Union, pardon me, not the European Union, the European Patent Office actually was founded in the 1970s at sort of the height of the time of resistance to software patenting, when this country had a decision called the Benson decision, which seemed to spell the end of software patenting. In that jurisdiction, the European Patent Convention actually says no patents on programs for computers. And yet the experience has been that that restriction has ultimately, as the technology has progressed, has ultimately fallen by the board, so that most practitioners think the European Patent Office practice is no different than American patent practice, despite this apparent per se restriction. And there's also a restriction in the European Patent Convention that forbids business method patents. And there's now academic studies that are showing that, in fact, there's a lot of things that are being patented in Europe, too, that are business methods. And that what we're seeing in business methods is there is this collapse between the machinery and the software and the business idea. They're all blending together into one unified technology. And that makes any sort of per se exclusion impossible. Jay said earlier, well, if you had a business machine like an automatic teller, you could surely patent that. Well, there's a spectrum. There's automated tellers, and then there's trading machines, and then there's software that actually implement machines. And it's very soon that you begin to realize that drawing sharp lines is a fool's errand in this area. I'd much rather, again, spend the time trying to actually do the project of figuring out the right scope for claims so they match an inventor's contribution and make sure that the claims are non-obvious the way the Supreme Court said they should be non-obvious. I know Cecil. Cecil was not going to remain quiet.
I couldn't resist. Now, I'm intrigued, John, by your aspirational patent system in which the non-obviousness standard limits patents to those inventions that would not have occurred but for the existence of the patent system, presumably excluding those that the normal forces of competition would produce, and in which the claims are limited solely to the contribution that the invention makes. How do we get to that patent? Or maybe I should start with the rhetorical question of, do we have that patent system? And if your answer is no, then the next question is, how do we get to that patent system?
Well, that's a great question. And I think that the thrust of my intellectual work over the last decade has been trying to get us towards that system. If you ask whether the Supreme Court law articulates these principles, I would say yes, it does. So I don't think we need change. We have to change some fundamental principles, which Jay sort of said, that we have to uproot things. I think we might have to uproot some lower court doctrine. And I know, Cecil, I know you're a big fan of the Federal Circuit, a really big supporter of it, but I think it's gotten a few things wrong from time to time. And I think that we might need some changes there. And I think it's much better to spend effort on that than to actually talk about these distinctions like, well, is it a machine or is it not a machine? Or is it, the Parker versus Fluke test? If you want to talk about a test that no one understands but Justice Stevens, you can talk about Parker versus Fluke. And Parker versus Fluke, I should say, began by saying, well, of course, a literal interpretation of the patent statute that we're dealing with here, Section 101. Of course that's impossible. Well, I know a little bit about the Supreme Court, and I don't think justices like Scalia and Roberts and Alito and Kennedy and Thomas are going to say, we just can't do a literal interpretation. We have to chuck that out the window, because Justice Stevens said it in the 1970s, that of course we can't do that. I think they're going to actually be attracted to looking to the text. And I think that's a much more solid basis for getting our patent system on track. The statute has tools in it to solve some of the problems. There are Supreme Court decisions that we can use to solve some of the problems. But this debate about business method patents, I think, is wholly beside the point and is actually draining away great thinkers like Jay Thomas from addressing those pressing issues.
Well, let me first, one big point of distinction between me and John is I'm not sure I've actually done any intellectual work my entire career. What I would say, and what a big critique that we hear from so many of my opponents in this debate, is that this Section 101 stuff is just really hard to do. It's difficult. You know, this is just something really hard to do, and there'll be some fuzzy lines here and there, and it's just not worth the candle. Well, my friends, welcome to the patent system. I don't understand why Section 1 law has to be crisp and clean, why Section 103 is a hazy case-by-case determination. I don't understand why we have to have patent eligibility. Just anyone can understand it. A child could do it right off the bat, while enablement, written description, and other requirements just tend to be very weighty and complex, and judges write dissenting opinions, and there's differences. Why is Section 101 supposed to be so much more of a crisp and clean standard? So I think you're imposing a desire upon this body of law that simply is not reflected in any other patent law doctrine. The demand for clarity and absolute precision here it means that the perfect is the enemy of the good in this case.
Can I say one more thing on that?
All right, I'll just say, look, one thing I think it's true that many things are standards, not crisp rules in the patent system. And I actually think that we should actually address the standards that are in the statute. And that has two advantages. One, there's at least a textual basis for what we're trying to do, like enablement or obviousness. This technological test or some other test, actually the government's brief I think has 5 different tests is sort of woven throughout it. That has no basis in the statutory language. That's a problem. That's going to lead to greater uncertainty because we don't even have an anchor for what we're driving towards. And the second thing is I don't think that there's any clear articulation of what the policy is behind it. We want to exclude something, but we're not sure. We've got multiple theories, and the amici on the side of the government have even more theories than the government has. At least with non-obviousness or claim drafting or enablement, we have pretty crisp articulations of what the policy is we're trying to achieve. We're just trying, it's hard to get there, but we know where we're trying to go.